Turn to the fourth case on this morning's docket, case number 121208 in the matter of Andrew M. Delaney.
Good morning, Penny Moylan appearing on behalf of the Disciplinary Administrator's Office. Chief Justice Nuss, I request 2 minutes rebuttal.
2 minutes is granted.
Thank you. This is an attorney discipline case, and as this court is aware, it has original jurisdiction over the cases. This case arises from 2 complaints. The first complaint involved a domestic matter, some post-divorce decree action that was requested to be taken on behalf of the client for Mr. Delaney, and the rules implicated there were both diligence and communication, 1.3 and 1.4. The second case arose out of Mr. Delaney's representation of 3 criminal defendants in tribal court. They were charged in separate cases, but it all involved the same criminal conduct. And the complaint alleged violations of a conflict of interest, 1.7, and then competence. And the competence arose out of the practice of not really obtaining full discovery before advising those defendants to enter into a plea agreement. And I'll touch a little bit more upon those cases a little bit later in my discussion. Mr. Delaney stipulated to the relevant facts and to the 4 rule violations that I just talked about, diligence, communications, conflict, and competence. And so really what we're here to talk today about is what is the appropriate sanction. Before I get into that, there's one more factual wrinkle. In 2014, Mr. Delaney was before this court, and part of that disciplinary action involved diligence and communication. It involved some other rule violations as well. The sanction imposed by the court at that time was a 6-month suspension, but they stayed the suspension, or you stayed the suspension, and placed him on a 2-year probation plan. So the probation plan was set to end in November 2016. The misconduct at issue in this case occurred prior to November 16, but the complaints were filed after November of 2016. Mr. Delaney, nevertheless, did not file any sort of motion seeking to terminate the probation. He wanted to stay on the probation. So that kind of brings us to the hearing panel.
So let me understand that
Sure.
the 2 complaints that are before us today occurred while he was on probation.
Correct. The tail end of it, but nevertheless, yes.
Thank you.
Just again to clarify, the conduct occurred while he was on probation?
I'm sorry, yes. The conduct occurred while he was on probation. The complaints were
That's
filed
And then
after.
did his probation end in 2016?
No, the way the probation process works is the respondent actually has to file a sort of motion to terminate the probation. He chose not to do that.
Even if, well, I understood you to say that our 2014 order suspending the respondent imposed 2 years of probation.
Correct.
And that doesn't expire automatically?
I don't believe it expires automatically.
Is that true in every case when probation is?
I don't want to say that. That's my understanding. We have an attorney in our office that sort of monitors the probation. That's my understanding of it.
So even as we sit here today, he's on probation?
Correct.
And he's continuing to comply, at least his
Yes.
statement is that he's continuing to comply with the original probation.
Yes, and I'll get to this as well, the hearing panel recommended additional conditions of probation, and Mr. Delaney and his supervisor have both filed affidavits to attest that he's complying with those additional terms. And meanwhile, Mr. Delaney's his probation practice monitor has continued to file quarterly reports that have all stemmed from that earlier probation.
For the last 5 years.
Correct, yeah.
And I was trying to look at the facts of the misconduct in this case.
Yes.
With an eye toward whether that tells us that probation is not the appropriate path to walk. And so what's your thought on
Right,
that?
I would like to talk about that. At the hearing panel, I requested a year suspension, but that it be stayed and his probation be extended for 2 years. And the first question I asked myself before I made that recommendation is, why didn't his probation plan cure or catch the misconduct at issue here? And I even asked the hearing panel that I thought this was a critical question for them to be able to answer in their head before they could recommend extending probation. And so this is what the evidence in the hearing panel kind of brought out. First of all, the tribal court case, it was pretty unique. And as I learned through this process is that things operate in tribal court a little bit differently. What I heard, there was evidence testimony at the hearing that oftentimes a defendant will be charged, offered a plea agreement, and sentenced all at the same hearing, all on the same day. And in that particular case, it's sort of what happened. Things happened very rapidly. Mr. Delaney, a lot of times the discovery is not provided prior to this, and so I'm not excusing the misconduct, but because our rules of professional conduct apply whether you're in tribal court, federal court, state court. So there was really nothing in the probation plan that talked about conflicts, talked about this sort of issue. In fact,
Do you have to know that? I mean, isn't conflict of interest just a real basic concept here, that you can't represent two clients that have a potential conflict, especially in a criminal case?
the conflict was not detected until Mr. Delaney realized that two of these defendants were actually related, that they all involved in the same criminal conduct, the same day that the plea agreement was basically, the plea offer was provided. And he had the discussion with the two clients, the two adult clients, and said, hey, this is the same case. I mean, I don't think the discussion was together. I haven't seen the discovery. There could be a potential conflict here. And the testimony was that they wanted to go ahead and enter the plea agreement.
So the idea is, or not the idea, but the evidence is that it all kind of came down all at once.
It did all come down at once. And again, not to minimize the misconduct, the reality is, if this had not had implications in federal court, it probably would have never come to anyone's attention that this was a problem. Because it did, and the federal public defender actually is the one who ended up filing the complaint. He filed a motion with federal court. The federal cases were dismissed, not because of anything to do with the conflict of interest, because some other unrelated issues. Mr. Folsom filed the complaint after all that happened, and at that point in time, there was some really frank discussions with the tribal court. And I believe, and I can't cite to the transcript, but I can tell you this, that the tribal court prosecutor was sort of dismayed that the situation had been allowed to be created. I mean, that he created some problems for Mr. Delaney. And so what has happened as a result of this is there are now 3 public defenders in the tribal court system. Mr. Delaney was the only public defender prior to that. And then all discovery is being provided at the time someone is appointed to the case. So they've made some changes within that, and Mr. Delaney, some of the conditions in the probation plan, as you can see that the hearing panel recommended, he's covering that himself. So I'm not sure the probation plan, the previous one, would have, like Justice Rosen said, maybe we should just know that, but I don't know that the probation plan was contemplating that sort of issue. What's more problematic is the domestic case. Yeah. Because the previous discipline did involve a domestic case, and it did involve some issues of diligence and communication. And this is the most I can tell you as far as this particular domestic case. Mr. Delaney was hired to represent this client and to obtain a decree of divorce, which he did after a trial. And in it, her husband owned a truck, her name was on it, she did not want to be on that truck. They got in the decree divorce an order that basically said the husband's going to be responsible for the debt, and that's all it did. So then she starts getting collection notices. And so to cut to the chase, this was not counted as an open file in Mr. Delaney's practice. He considered this a closed file because he had obtained the divorce. That does not excuse the lack of communication when she continues to call him afterwards and say, you know, I need something taken care about this, and I think he can address that better. The probation plan talked about a communication log that involved telephone, keeping track of his telephone, and he absolutely did that. I can tell you the evidence of record in this case, this client, she emailed him, and she emailed him at night, because that's when she worked. And that's actually when she would email me about this case too. Again, I'm not excusing the misconduct of not responding to the email communications, but you know, those are the only 2 reasons I can really tell you why it slipped through the cracks of that probation plan. Let's see.
From where we're sitting though, we've got a kind of a public safety command here, and I guess I'm not feeling real comfortable from that perspective. I understand the good faith that's being talked about by the parties and all that. It's just,
I understand that, and I think it's the difficult position that this court has always placed, as well as our office. And I know I've stood before you a month ago and explained that I understand that our duty is to protect the public. I do think in this particular case that the additional provisions that have been put in, not handling any more domestic cases. He hasn't since 2016. Mr. Delaney realizes that these are not the types of cases he should be handling. He has the tribal court issues that I've already talked to you about. The communication log now is documenting every single email that comes in. This wasn't part of the probation plan, but the evidence presented at the hearing was that his caseload has significantly reduced. I think he can tell you specifically where he went from at one point in time to where he's at now. There were 4 witnesses that came, including the practice supervisor, that really testified in his favor. I understand. I think that anytime you have someone that's been placed on probation and there's problems after the fact or even while they're on probation, the question is, does probation work? And I just am going to go back to, I think, sort of the unique circumstances of each case that has to be viewed in its entirety, and looking at maybe not quite as unique, but sort of the different circumstances, especially the tribal court case. I'm going to stand on I think I have to stand on my recommendation, but I feel comfortable based upon the additional conditions of probation and what Mr. Delaney has done to make the recommendation that...
Given all those circumstances that you just described, if we set aside the probation aspect of this case, is a 1-year suspension justified as a discipline for this behavior, given these circumstances?
I think that's a really good question, and I'm always nervous to say this because when I was looking at the ABA standards, and when you don't take into effect the aggravating or mitigating circumstances, this is almost sort of like a gray area between a reprimand and a suspension. But I think you have to look at the aggravating factors of previous discipline. This happened while I was on probation, that a 1-year suspension.
But if you look at aggravating, you would also look at mitigating, and you just recited a whole bunch of mitigating factors. And so it seems hard to me where it's on the line between censure and to go then all the way to 1 year.
I think a 1 year is kind of the stick. That is
but is that, I guess that's my question. Is that an appropriate way for us to manage these cases? Because we're going to consider probation, we're going to jack up the underlying.
Well, I think there's more at risk here. I think when you've been given a second opportunity and you still are saying, well, I can't, I think what we're looking at is saying the safety to the public.
I'm not sure we would tolerate that. And I know this is not the same as a criminal context.
Right.
But I'm not sure we would think it was appropriate to just have an inappropriate penalty imposed just because we're going to place the person on probation.
Yeah, and I guess I would go back again to, I mentioned without the aggravating or the mitigating, it's kind of an iffy deal. But I do think the aggravating, taking probation aside, when you have prior misconduct that was a 6-month suspension, would probably warrant the year.
Okay. Thank you.
I have one quick fact question,
Yes.
just for you to refresh my memory. The complaint on the current complaint having to do with the domestic case.
Yes.
That complaint was lodged pretty quickly, correct? And one of the complaints was he's not communicating, and in fact, before he became aware of the complaint, he communicated, right? She had tried to reach him, wasn't getting quick
Correct.
satisfaction, filed the complaint, but before he became aware of the complaint, he had in fact responded to her.
Correct. And during that time frame, I'm sorry, was there
No,
a
that's okay.
follow-up question? The time frame started about, I think the divorce decree was entered in the month of September.
Mm-hmm.
And then starting in November, there was lots of emails. Sometimes he wouldn't respond. Then he'd bring her in and say, okay, let's try this. And so throughout that, there were time periods of him meeting with her. And again, I get nervous making these arguments. I do think this was someone that had high expectations of lots
That's
of
what I'm trying to get to.
Absolutely.
Not that clients shouldn't have high expectations. We'll acknowledge that as a baseline. But it struck me that it's far from the most egregious lack of communication and diligence case we've ever seen.
I would agree with that assessment.
Okay, thank you.
Any further questions? Thank you, counsel.
Thank you.
May it please the court. J. David Ferris for the respondent, Andy Delaney. I don't want to take up very much of your time because I totally agree with the recommendations of the disciplinary administrator and the hearing panel, that being suspension, but suspend the suspension and place him on probation. I have worked with Mr. Delaney since he started practicing law. I've been in front of this court 4 years ago with Mr. Delaney, and it is amazing to me, to his colleagues, to the people that testified for him at the hearing panel, of what a vital service he does for Brown County and the city of Hiawatha. He has not taken a domestic case since 2016. He has become the city attorney for the city of Hiawatha, which is taking up a lot of his time. He was instrumental in changing what went on with the tribal court, and he does do appointment work in Jackson County. I think he's worth saving, and if I could, Chief Justice Nuss, I would like to give the rest of my time to Mr. Delaney, who would like to address you.
That's acceptable.
Thank you.
Good morning. May it please the court, thank you for allowing me to address you. I would like to apologize for any inconvenience my actions have caused this court. I certainly would like to apologize to the disciplinary administrator's office for the same inconvenience that my actions have caused. When I was here before the court, was placed on a period of probation for 2 years, and that started in November of 2014. For the first 18 months of that probation, I scaled my practice back quite a bit just to make sure I could ensure with the conditions that were placed upon me. In fact, the same conditions we recommended. With about 6 months left on my probation period, I believed it was a good time for me to try to re-expand my practice to include helping people with their domestic issues more often. It wasn't a flip decision, it was one I discussed with my practice supervisor. So through the end of 2016, I did do that. It was not the correct decision for me to make. During that 6 month period of time, I discovered that it's an area of practice that I'm not the best at. It's a limitation that I have that I couldn't perform the way my clients deserved. They deserved a better attorney. So prior to Ms. Young filing her complaint, we had, after speaking with my practice supervisor, kind of reached this decision that it wasn't going to work out, and we'd begun the process of scaling back our practice after that. I do remember the end of 2016 as being not a good time. I didn't like going to the office. It was the work. Following Ms. Young's complaint, which was, I think, right around the first of the year in 2017, we changed the office practice. I say we, it's me and I have a secretary. So we're a team. We did this kind of stuff together, stuff we talked about. But scaling back the practice, not including domestic cases, I do not engage in the practice of civil cases typically as well. I limit my other cases. It was relying mostly on court-appointed work at that time. And then at the end of 2017, I was fortunate the city attorney position came open with the city of Hiawatha, and I was appointed to accept that position almost immediately overnight. That allowed me to withdraw from about 1/3 of my cases, where I was carrying probably 300 to 350 open cases on the court-appointed work at a time. I was immediately allowed to scale back to somewhere between 200 and 250, and that's the way it's been since those are the Jackson County appointments that I take. So that was, I think, the best thing that's ever happened to me as an attorney. It's work that I enjoy and work that I would like to continue doing. I don't have an excuse for the cases that came down in Kickapoo Tribal Court. I should have made a better decision. I made a poor decision. I made a mistake. I allowed my clients to enter this plea without looking through the discovery, without determining if there was a conflict. I have waivers of conflict forms that comply with Rule 1.7. I didn't have them fill it out. And although I thought we discussed it on the record, there was no record of my conversation with my clients. So I am thankful now that the judge has given 2 other attorneys positions on the court-appointed list down there. Discovery is more forthcoming, and that simply is not a situation that's going to be not a situation that's going to repeat itself. When I was here before the court last time, I told you that I was feeling better as far as the mental health concerns that I'd had in 2012 when my original actions occurred. That was true. I can tell you today, I feel better than I did 3 years ago, even 5 years ago. So, and a lot of that has to do with the type of practice that I'm working today. I understand it's an unusual request to ask for my probation to be extended, but that's what I'm going to ask you to do today. I enjoy the practice of law that I have today. More and more, but having fewer and fewer attorneys, especially in Northeast Kansas. Good ones are retiring, judges are retiring. So, but I want to be one of those attorneys. I would like to be one of those attorneys in Northeast Kansas, and I would ask that you give me the opportunity to continue doing that. I don't have anything further, but would be happy to answer any questions you might have.
Do we have any questions? All right, thank you, counsel.
Thank you.
I just have one point of clarification and I'm done unless the court has questions. My recommendation would be to extend 1 year suspension, but to suspend that and extend Mr. Delaney's probation period for 2 years from the date of this court's decision with the conditions that were specified in the hearing panel report. And that's all I have, unless the court has some questions.
I'll ask a question out of turn. That is agreeable to the respondent, those additional conditions?
Yes, sir.
All right, do we have any more questions? Thank you, counsel.
Thank you.
We thank all of you for your arguments this morning. Court will take this matter under advisement